we're going to let Sharon, she's going to do the talking. Now, Sharon, it speaks a little slow, so we're gonna bring Sharon down a little bit. But what we're going to do is we're going to let y'all listen to something, because we want to talk about commercial arbitration and what's the trend now in the United States. Okay, especially about the class action. Okay, because class action law arbitrations, I did not know it was even possible. I just did it. Understand, for the defrauded homeowners of America, for the SAT-PAC personnel, and did another one for the what we call the affidavit group. Did a lot of affidavits for people, and the court ignored those affidavits. So we did an arbitration regarding those affidavits. Okay, so all class actions. Let's find out if I was right when I assumed. I assumed, okay, because I want to make an anus out of somebody. Let's see if I was right. Come on, Sharon. She's a little shy.
Commercial arbitration is extensively used in the U.S. to resolve a wide variety of business disputes, from ordinary contract disputes to more specialized disputes in the construction, energy, real estate, financial, banking, and insurance sectors. New York is typically regarded as the center for commercial arbitration in the U.S., and has a well-developed statutory and jurisprudential framework for adjudicating the sorts of arbitration-related disputes that commonly make their way into courts. This chapter focuses primarily on arbitration cited in New York, or which invoke the New York court systems. Much of the prominent recent jurisprudence on arbitration in the U.S. has concerned the availability of class action arbitration, typically arising out of consumer contracts. In 2010, the U.S. Supreme Court held that class action arbitration is permissible, but only where the parties have clearly reached an agreement to arbitration with a class of persons. Stolt-Nielsen SAV.
Oops.
Animal Feeds International
I'm so
Corporation.
glad that we reached that
Court
agreement.
1758, 2010. After this, arbitration clauses in contracts are increasingly drafted to expressly prohibit class action arbitrations.
Ours isn't.
These class action waivers have been challenged on various grounds, recently making their way to the Supreme Court. In 2013, the Supreme Court ruled that class action arbitration waivers in commercial contracts are enforceable in certain circumstances to prevent class arbitrations, even those based on alleged violations of federal statutes. See American Express Company v. Italian Colors Restaurant, 133S. Court.
It's a Superior Court matter, 2013. We're going to scroll down a little bit. It's frozen, so y'all just going to have to wait for a minute. But that just lets you know that they're trying to stop every type of remedy that people are finding. They're trying to prevent that, and it's the corporations trying to do it.
2304, 2013.
Come on, Sharon. Be a good girl. Sharon is a little slow, y'all. I told you she was a little slow. I didn't think she was going to be this slow. So let me pause her for a second and pause y'all. Oh, yeah, she's spinning. Got me going in circles. I should play that song. I haven't heard that song in a... I got a song that ain't got no melody. I'm gonna sing it to myself and my friends. Okay, so we're gonna wait for it to
Again in
catch up.
2016.
Stop it. We're gonna pause y'all for just a second. I have to change some things, so 1 second. Okay, Sharon's gonna start right here, y'all, so 1 second.
Again in 2016, the Supreme Court upheld the validity of class action arbitration waivers in consumer agreements, overturning on federal preemption grounds a California Court of Appeals finding that a class arbitration waiver provision was unenforceable under state law. DirecTV, Incorporated v. Imburgia, 136S Court 463, 2015. In May 2016, the Consumer Financial Protection Bureau released for public comment proposed rules that would prevent covered financial services entities from using a consumer agreement that provided for the arbitration of disputes relating to financial products or services, but barred a consumer from pursuing a class action related to those disputes. See question 37.
You know, I'm surprised the Roberts Court has been doing this, but then government is for corporation because government is a corporation. So I am not surprised that they protect the corporation because That's government.
In other recent developments, U.S. courts in 2015 have issued several important decisions clarifying the respective roles of courts and arbitrators in connection with actions to compel arbitration. First, in January 2015, the U.S. Court of Appeals for the Second Circuit, which hears appeals arising from federal courts in New York, Connecticut and Vermont, held that the question of whether a federal judgment confirming a prior arbitral award precludes subsequent arbitration of claims is a question for arbitrators, not the courts.
Exactly.
Incorporated v.
It
Abu
is a question
Dhabi.
for arbitrators. I love that. I love that decision, that the courts have no jurisdiction.
Auth. 776F.3D 126, Second Circle.
Abu Dhabi Investments.
2015. The case arose out of a long-running dispute between the Abu Dhabi Investment Authority (ADIA) and Citigroup, Incorporated over a failed investment.
The Abu Dhabi Authority.
ADIA had lost an initial arbitration, and that decision was confirmed by the New York federal courts. When ADIA commenced a second arbitration arising out of the same investment agreement, Citigroup sought an order in the Southern District of New York, seeking to enjoin the arbitration, on grounds that ADIA's claims were barred by the doctrine of res judicata. The district court denied Citigroup's motion to compel arbitration on the basis that Citigroup's res judicata defense was a matter for the arbitrators. The Second Circuit, in affirming on appeal, observed that the Federal Arbitration Act's (FAA) policy of favoring arbitration indicates that it is for the arbitrators, not the federal courts, to determine the claim preclusive effect of a federal judgment that confirms an arbitration award.
That's why arbitration is so important, because the courts have ruled that the courts have no jurisdiction, especially in making certain determinations which certain courts tend to make. Is in this case, the district court said it denied the motion for the arbitration, said it was barred from doing it, but we see that some state courts and some district courts are making decisions despite having these long-standing laws, and that's what's killing the process. Now, my system is a resource issue right now, so you're just gonna have to be patient, y'all. Just be a little bit patient. Come on, Sharon. You can do it, girl. So, now, remember, these are all New York cases. The reason why they're New York
In July
cases.
2015, the Second Circuit, in Katz v. Selco P-Ship, 794F.3D 341, 343, Second Circle.
District.
2015, clarified the proper procedure a federal court is to employ following a successful motion to compel arbitration.
Now, this is a motion to compel arbitration, which is different. This is a motion where you want to force arbitration. And they're going under the FAA, Federal Arbitration Act.
The question for the court was whether the FAA requires a federal court in a matter in which it has referred all claims to arbitration to stay the matter before it, or whether a court possesses discretion to dismiss the case outright.
No discretion. I already know that. Ah, look at that. Leaves a district court with no discretion. I knew it! I knew it because I read the Federal Arbitration Act. Statutory interpretation. It literally says that the courts have no discretion.
The court concluded that Section 3 of the FAA leaves a district court with no discretion to dismiss the case, and that it instead must stay the trial of the action during the pendency of the arbitration. Although perhaps counterintuitive on first blush, the court's determination that a stay is mandatory actually comports with the FAA's pro-arbitration policy. For while a final dismissal order gives a losing party an immediate right of appeal, which could potentially lead to further litigation in contravention of the pro-arbitration policies of the FAA, there is no right to an immediate appeal from an interlocutory order staying proceedings while a matter is referred to arbitration.
So, ladies and gentlemen, what they're saying that if you have
Therefore,
a pending case, pay attention, and your matter, there's an arbitration policy within your contract, the arbitration takes precedent over the pending case. That's the whole issue. The pending case is stayed while the matter is being arbitrated. See, arbitration, the alternative dispute resolution was to help remove a lot of congestion in the courts and get rid of a lot of the legality of them having to do this and having to do that, and you know, going through these hoopla. I got to change the screen, so give me a second to change my screen. Not like that. I can't change it like that. I got to do it. Okay. All right. Didn't change it because it won't let me change it the way I want to change it. So that's the best I can do for now. All right. So that's what they just said. That there is no right to an appeal from an order staying a case. So the people can't appeal what the judge decided because arbitration takes precedent. That's what it was saying. So let's finish, y'all. This is just to let you guys know the research has been done. Okay? Because a lot of people are trying to question me. I haven't even read this stuff.
The effect of the Second Circuit's decision is to curtail potentially disruptive appellate litigation while an arbitration proceeds.
Told you. Without even reading it, I told you it's to keep down congestion. Because attorneys would use this as a way to clog up the courts, to slow things down, to interfere with arbitration. See, both decisions
are viewed as reaffirming the strong pro-arbitration policy of the FAA, as well as reinforcing the reputation of the New York federal courts as being very supportive of arbitration.
You better believe it.
Advantages/disadvantages. Commercial arbitration is often regarded as having several distinct advantages over court litigation, including potentially greater speed and efficiency than typical court litigation.
I like the privacy and confidentiality. Yeah, court proceedings are public. So that's what she's getting ready to do.
Privacy and confidentiality, at least in the sense that unlike court proceedings, arbitral hearings are closed to the public.
Oh, look at that. However, in the context of judicial enforcement and challenging proceedings, arbitral awards are often publicly disclosed. So yeah, it's okay that it's publicly disclosed. We don't care about that. Now, the freedom to select the decision maker, that's a pro.
However, in the context,
gotta let her catch up, y'all. So hold on.
Judicial enforcement or challenge proceedings, arbitral awards often are publicly disclosed.
Yeah, there's something going on. The system just don't like what's going on, y'all. And I want the system to change up because it's stuck. It won't even let me go down to my status bar at the bottom. My little task bar, it says you ain't going nowhere. So we just stuck. So we have to wait for Sharon. She's slowing us down, y'all. Sharon, you're going to have to get on the bus. So 1 second, y'all. Okay, we had to start it all over again, y'all. It's like that song, starting all over again. It's gonna be rough. Well, it's gonna be rough, y'all, because we gotta go. I had purging the matrix earlier. We did that early to December 23rd. We did that earlier today. But gotta start it all over again. And the way we get rid of purging the matrix is we minimize this, because that's the only other problem with this software, is when you are selecting a document and you want to delete everything. It ain't easy, okay? It takes this little sweet time, okay? It literally takes this sweet time. You know what? I wasn't supposed to choose this document. There's too much in this document. So, no, let's go back to library. There's too much in purging the matrix. Whew, there's a whole lot of stuff. We got purging the matrix. It's saved to the computer. This is the one I have to minimize. Minimize. Give me my 718 Windows. Okay, we're going to go from here, because we started from the top, or the bottom. Now we made it to the top. That's where we're going. We're going to delete y'all. And now we take this last one, delete it. Uh-oh, thought that was the last one. It wasn't the last one. This is the last one. Got to keep going up to the top because we started from the bottom and we ain't made it to the top yet, y'all. So y'all just hold on. I would have put y'all on pause while I did this, but the system is not letting me. There you go. Get all the way over there, cover that, and get rid of that, and then you paste that back. So we got to wait a second for it to show up. TikTok. And we're not going to use Sharon no more because Sharon's been having some problem. Let's see. We'll use Josh. Josh a youngster, okay? We're going to use the youngster because he kind of knows what he's talking about. So we're going to let him explain the law to y'all. So we can go back to the advantages and disadvantages. And we're going to get rid of this stuff here because we already read about the circuit court and them making them decisions. And that's the point, ladies and gentlemen. What we're trying to say is Mr. Starks did this research back in 2013, 2014, finding out this was his out. Why? Because the Pro-Arbitration Act, known as the Federal Arbitration Act, is there for our benefit. So we're going to start back with the advantages of the lawmaking. Now see, as I told you about this particular software, what I do like about it is this, that I get to make it the full screen if I want to. Before, you couldn't do that with this software. Before, you were restricted to a little view window, and that was irritating. Now, I believe I know what the problem was that was interfering with the voice, and I believe it was Dragon. Let's see, it don't want me to make this thing bigger, so let's do it. Oh, Dragon still hasn't shut down. I'm shutting it down though. Yeah, it still hasn't shut down, so we're gonna shut it down. That's why I don't want to go any higher. So come on down, right there, like the way you do that right there. And microphone is asleep. Turn it on. Nope, it's shutting down. That's why it's grayed out. It's shutting down, but it's taking its time and it's getting on my nerves. Alright, let's go ahead and let Josh read to y'all. So y'all hold on now. He's kind of fast when he talks. Come on, Josh. Don't wait on us.
Advantages/disadvantages. Commercial arbitration is often regarded as having several distinct advantages over court litigation, including potentially greater speed and efficiency than typical court litigation. Privacy and confidentiality, at least in the sense that unlike court proceedings, arbitral hearings are closed to the public. However, in the context of judicial enforcement or challenge proceedings, arbitral awards often are publicly disclosed. Freedom to select the decision makers. Freedom to select the procedural rules, usually through designation of specific institutional arbitral rules or procedures, and typically greater flexibility of process.
Yes.
More limited discovery than U.S. court litigation. Avoidance of having a dispute heard before the opposing parties' potentially hostile home courts, judges, and jurisdictions. This factor is especially important in the context of international commercial arbitration. More limited grounds for challenging awards than in a typical judicial appeal process, and therefore potentially greater ease of enforcement for prevailing parties. Greater ability of willing parties in arbitration to recover their fees and costs as opposed to U.S. court litigation, where under the American rule, attorneys' fees are presumptively borne by each party. Many of these perceived advantages can also be regarded as disadvantages depending on a party's position in the dispute. For instance, losing parties may desire a wider scope of judicial review to challenge arbitral awards. Additionally, particularly in high-value commercial disputes, where there has been a trend towards greater document discovery and parties often seek regular court intervention, some of the traditional efficiency advantages of arbitration may be eroding.
Uh-oh. Come on, legislative framework. Applicable legislation. Now, here's the part where you need to understand.
Legislative framework applicable legislation to. What legislation applies to arbitration? To what extent has your jurisdiction adopted the UNCITRAL Model Law on International Commercial Arbitration 1985, UNCITRAL Model Law? International commercial arbitration cited in the U.S. are primarily subject to the U.S. Federal Arbitration Act, FA 9 Us. See Section 1 at SEC, including its Chapters 2 and 3, which respectively codify U.S. ratification of the New York and Panama Conventions, see Question 34. Additionally, each U.S. state, including New York, has its own state arbitration legislation, see, for example, Article 75, New York Civil Procedure Practice and Rules, CPLR. While the FA preempts and displaces provisions of state arbitration law that are deemed inconsistent with the FA and its pro-arbitration policies, where state laws are not in conflict with the FA, state and federal law can coexist. Mandatory legislative provisions. 3. Are there any mandatory legislative provisions? What is their effect? Both the FAA and the CPLR may apply to arbitrations in New York, and provide the legislative framework for enforcing agreements to arbitrate and for enforcing and challenging arbitral awards. Typically, U.S. law gives broad effect to private agreements to arbitrate, consistent with the strong presumption in favor of arbitration in both federal and state law. U.S. courts are often reluctant to interfere with parties' agreements over the form or scope of arbitration. However, some narrow categories of disputes, such as disputes over divorce or child custody, have been deemed to be non-arbitrable. Additionally, federal courts in New York have suggested that parties are not free to contract to limit the grounds for challenging an arbitral award below the baseline vacatur provisions set out in Section 10 of the FAA. See Question 29. See, for example, Hoft v. MVLGRP. Incorporated, 343 F.3D57, 64-65, Second Circle.
See, it says it right here,
2003.
Section 10 and 11.
At the same time, the U.S. Supreme Court has held that grounds for vacating or modifying awards set out in Sections 10 and 11 of the FAA are exclusive and cannot be expanded by the parties' agreement. Hall Street Associates v. Mattel, 552 U.S. 576, 2008. Despite this language, some U.S. courts have recognized manifest disregard of the law as an additional ground for vacatur. Courts in New York apply manifest disregard sparingly, and tend to view it as a judicial gloss on the enumerated grounds for vacatur. See Question 29.
Come on, let's find out if the law prohibits just any type of dispute from being resolved, including cases where individuals are incarcerated. Come on, Josh. What's wrong with this? Josh 22K is Josh. So we gotta wait for the 22K-year-old to speak to us.
4. Does the law prohibit any types of disputes from being resolved by arbitration? The FAA does not prohibit any types of disputes from being resolved through arbitration, and typically U.S. courts have been wary of any efforts to limit the availability of arbitration for any particular classes of disputes.
I like this right here. Europe has already done this.
This represents a departure from the practice of a number of European and other countries, where states more aggressively police the use of mandatory pre-dispute arbitration agreements in certain classes of agreements such as consumer contracts. Nonetheless, attempts have been made over time to try to place certain classes of disputes beyond the purview of arbitration. In a seminal 1985 decision, for instance, the U.S. Supreme Court rejected an argument that the strong public interest issues at stake in antitrust matters rendered such claims non-arbitrable. Mitsubishi Motors Corporation v. Solar Chrysler Plymouth Incorporated, 473 U.S. 614, 1985.
Yeah, we still got the feedback type thing going on. Let me see. I'm going to have to minimize him for a second. That's it.
While the court acknowledged lower courts' concerns about the appropriateness of arbitrators deciding matters that so directly implicate the public interest, it noted that courts would have an opportunity to review the consequent award at enforcement stage, albeit on the more limited grounds available for challenging arbitral awards within the FAA New York Convention at 638. Additionally, in recent years efforts have commenced to place certain classes of consumer finance transactions beyond the purview of arbitration. The 2009 Dodd-Frank Wall Street Reform and Consumer Protection Act, Dodd-Frank Act, for instance, explicitly bars pre-dispute arbitration agreements in mortgage and home equity loans. The Dodd-Frank Act also amended the securities laws to prohibit the use of such clauses in financial industry whistleblower disputes covered by the Sarbanes-Oxley Act. Under the Dodd-Frank Act, the Consumer Financial Protection Bureau, CFPB, was also charged with studying, and potentially regulating, the use of pre-dispute arbitration agreements in consumer finance transactions, and has recently indicated that it is in the process of drafting proposed regulations. See Question 37.
See, they're trying to regulate
Some states
people.
also have attempted to preserve rights to seek judicial redress for certain types of claims. For instance, California courts have held that certain statutory remedies brought under private attorney general provisions, such as claims for injunctive relief under certain consumer protection statutes, are non-arbitrable. Limitation 5. Does the law of limitation apply to arbitration proceedings? where parties have contracted for the application of New York law. New York statutes of limitation for various claims can be asserted as defenses in arbitration. Section 7502(b) of New York CPLR may be read as granting arbitrators more discretion than a court would otherwise have in applying limitation periods.
Come on, give me that statute in Section 7502(b), how it notes that arbitrators may, in their sole discretion, apply or not apply a statute of limitations.
Section 7502(b) notes that arbitrators may, in their sole discretion, apply or not apply a statute of limitations that would otherwise bar a litigant from raising his claims before a court of the state. New York law prescribes different limitation periods for different categories of claims. For instance, claims for breach of contract and fraud are subject to 6-year limitation periods, whereas many categories of injuries to persons and properties are subject to a 3-year limitation period. Sections 213 and 214 CPLR.
But if it's an injury, you only get 3
of
years?
Statutory limitations periods may be available under New York law in some instances, in which the facts giving rise to the claim are concealed or otherwise unknowable. Arbitration Organization 6, which arbitration organizations are commonly used to resolve large commercial disputes. The following arbitration organizations are commonly used to administer large commercial arbitrations in New York. The American Arbitration Association, AAA, www.adr.org, and its International Center for Dispute Resolution, ICTR, www.adorg/ICTR. The ICTR administers all international arbitration cases for the AAA, and shares a New York City office with the AAA. The International Chamber of Commerce, IC, www.icpo.org/products-and-services/arbitration-ADR, which has opened a New York City office to administer arbitrations in North America. The Institute for Conflict Prevention and Resolution, CPR, www.FUDR.org, which maintains its headquarters in New York. JAMS, www.jamesitter.com, which, although headquartered in California, has a New York office and a roster of potential arbitrators in the New York area. The Financial Industrial Regulatory Authority, FINRA, www.finra.org/arbitration and mediation. FINRA operates the largest dispute resolution forum in the securities industry, to assist in the resolution of monetary and business disputes between and among investors, brokerage firms and individual brokers. It is used primarily in domestic cases. CBOX, Main Arbitration Organizations.
Let's deal with the jurisdictional
issues 7.
Oh, by the way,
what remedies are available where one party thinks that the tribunal has jurisdiction to...
Hold on. All of those agencies that you just saw, every single one of them. Let's go on up. The Financial Industrial Regulatory Authority, FINRA, the JAMS, jam on it anyway, the CPR, Corporal Pulmonary Resuscitation, anyway, Conflict Prevention and Resolution, that's why they call it CPR, and the ICC, the International Chambers of Commerce, and then you have the ICDR, which is the International Center for Dispute Resolution, which is part of the American Bar Association's American Arbitration Association. These are all private organizations, ladies and gentlemen. That is the point. They're all private organizations. There is nothing governmental about any one of them. Let's go on to jurisdictional issues. We need to find out what's going on with jurisdiction.
To determine the dispute, S. Does your jurisdiction recognize the concept of competence? Does the tribunal or the local court determine issues of jurisdiction? An arbitral tribunal's ability to hear a party's dispute over jurisdiction, the question of arbitrability, depends on whether the parties have agreed to arbitrate jurisdictional disputes. If the parties have agreed to submit the arbitrability question itself to arbitration, the tribunal can hear those disputes.
We're going to start here. He was not in sync.
An arbitral tribunal's ability to hear a party's dispute over jurisdiction, the question of arbitrability, depends on whether the parties have agreed to arbitrate jurisdictional disputes. If the parties have agreed to submit the arbitrability question itself to arbitration, the tribunal can hear those disputes. In contrast, if the parties did not agree to submit the arbitrability question itself to arbitration, a court should decide that question.
That's why our agreement, the parties have agreed. and it's wonderful. That's why
Under applicable case law, a court should not assume the parties intended to arbitrate arbitrability unless there is clear and unmistakable evidence that they did so.
Yes, there has to be an
See First
arbitration
Options of
clause.
Chicago v. Kaplan, 514 U.S. 938, 944, 985, 1995. Citing AT&T Technologies, Incorporated v. Com Single Quote NS Workers of AM. 475 U.S. 643, 649, 1986. See also v. R.G. Linhers S.A.V. Medlin Patterson Global Opportunities Partners 2LP, 717 F.3D 322, 325-26, Second Circle. 2013.
Second Circle.
Courts typically find that the parties' designation of arbitral rules that expressly give the arbitrators power to decide questions of their own jurisdiction manifests the necessary, clear, and unmistakable intent. At 326, an arbitration clause subjecting disputes to the rules and procedures of the International Court of Arbitration clearly and unmistakably commits to arbitration any questions about the arbitrability of particular disputes. Without clear language or incorporation of such rules, however, there is a presumption that the court will decide jurisdictional disputes. Republic of Iraq v. ABG, 769 F sup. Second, 605, 610, SDNY 2011.
Ladies and gentlemen, that's why the arbitration section is so long, because those are the arbitral rules for the arbitration. Like I said, the document already includes everything that it needs to include. There are going to be people who are going to want to try to change things, and please understand, when we put together the contract, we made sure that we incorporated all of this. Well, as a matter of fact, Bradley Starks, okay, Bradley Christopher Starks, BCS, made sure that these provisions were there. Why? Because this is the information he went over. He studied this. I've never studied this stuff, ladies and gentlemen. This is my first time seeing this document, but I already understood all of these points right here, because these are basic fundamental principles of dealing with the courts. All right, let's continue. Shall I continue? Yes, you may. Now, Peter Pipe, pick pepper.
Aft Subnom. The Republic of Iraq v. BNP Paribas USA, 472 FF single quote text 11, Second Circle.
Second
2012.
Circle. It's a circle. Gotta be a part of the circle, y'all. Now, validity requirements. Let's see if the arbitration agreement is enforceable. Are you guys ready for that? Because I'm interested to see if our arbitration agreement is enforceable. Let's see if we've dotted our I's and crossed our T's. Because it is absolutely necessary. Like, again, I keep saying, Bradley Christopher Stark is the man who gets the credit for this. Why? Because I never would have jumped on the bandwagon of arbitration. I did not know it had all of these protections for us.
Arbitration agreements validity requirements 8. What are the requirements for an arbitration agreement to be enforceable? Substantive/formal requirements. The only substantive or formal requirement is that an arbitration agreement must be in writing. Section 2. Courts are not overly...
Wait, hold on. The only substantive or substantive or formal requirement is that the arbitration agreement be in writing? No, it can't just be that easy. The courts are not overly formalistic in ascertaining whether the parties have evidenced a written intent to arbitrate. They have enforced arbitration agreements where, for instance, an agreement was manifest through the exchange of writings, including emails, rather than a formal contract document. Imagine that! Amazing! Let's continue.
Formalistic in ascertaining whether parties have evidenced the written intent to arbitrate. They have enforced arbitration agreements where, for instance, an agreement was manifested through an exchange of writings, including emails, rather than in a formal contract document. Separate arbitration agreement. An arbitration agreement can be made through a separate, even later executed, agreement from the main contract governing the subject matter of the dispute, although it need not be. Frequently, parties set out their agreement to arbitrate through a clause in the underlying agreement. Either form of arbitration agreement can be upheld by U.S. courts. Unilateral or optional clauses 9. Are unilateral or optional clauses, where one party has the right to choose arbitration, enforceable? Unilateral option clauses.
Wait, hold on. Unilateral contracts, is it possible? Let's see this, because like I told you, I ain't studied this. But some people have been telling me I've been misleading people about this stuff. So let's see if I have been. Let's see if I know what I'm doing, and these idiots who are talking don't know anything about what they're doing because they haven't done any research.
Also known as one-sided or asymmetric clauses, provide for one method of dispute resolution, but also give one party the right to elect to refer a particular dispute to another dispute resolution forum. Generally, unilateral option clauses provide for arbitration as the default dispute resolution mechanism, but give one party the right to bring the dispute to the courts instead.
Nope.
This gives the party holding the option the ability to choose between different forums depending on the advantages they provide, and defer the decision of which forum to pursue after a dispute has arisen. The law regarding the enforceability of unilateral option clauses in the U.S. is not well established. However, U.S. courts have occasionally found unilateral arbitration clauses, or clauses whose terms oppressively favor one party, usually an employer, to be unenforceable. For example, U.S. Court of Appeals for the Fifth Circuit, applying Louisiana law, for example, invalidated a clause in a consumer contract that required consumers to arbitrate all of their claims, but allowed the cellular telephone provider to choose between arbitration and litigation for its claims. Iberia Credit Bureau, Incorporated v. Singular Wireless LLC, 379 F.3D 159, 168-71, 5th Circle. 2004. In light of the one-sidedness of the duty to arbitration, the Fifth Circuit held that the clause was unconscionable. In Engle v. Circuit City Stores, Incorporated, 328 F.3D 1165, 9th Circle. 2003, the Ninth Circuit, applying California law, struck down an arbitration clause on grounds of unconscionability because certain of the arbitration agreement's terms were oppressively one-sided.
And you cannot make it one-sided.
These included terms that limited the scope of the arbitration clause to the sorts of claims that employees would likely bring against the employer, but leaving the employer free to litigate other types of claims against the employee, and which gave the employer the unilateral right to modify or terminate the arbitration agreement. 10. In what circumstances can a party that is not a party to an arbitration agreement be joined to the arbitration proceedings? The Federal Arbitration Act, FA, is silent on consolidation of separate arbitration proceedings and joinder of non-parties to an arbitration.
Ladies and gentlemen, that's the one thing we're not doing. We are not invoking or bringing in parties who are not parties to the agreement. And in the unilateral portion of the contract, the individual has the right to choose arbitration. They have the right to choose an independent arbitrator. But they don't choose that. They choose instead to tacit acquiescence, which gives us the complete right to choose the arbitrator. Okay. That's all we did. So, right in line with law. So it's not unconscionable that someone would waive their right. And that's why we put in there that it will stand as a waiver of rights. Let's continue, shall we?
As arbitration is fundamentally a matter of contract law, the law generally protects a non-consenting party from being compelled to join an existing arbitration proceeding. However, state procedural laws may provide such a mechanism. For example, Section 1281.3 of the California Arbitration Act, CAA, Cal Code Civ P paragraph 1280 to 1294. 4. Permits a court to order consolidation of separate arbitration proceedings when three circumstances are met. Separate arbitration agreements or proceedings exist between the same parties, or one party is a party to a separate arbitration agreement or proceeding with a third party. The disputes arise from the same transactions or series of related transactions. There is common issue or issues of law or fact creating the possibility of conflicting rulings by more than one arbitrator or panel of arbitrators. There are limited circumstances in which a non-signatory to an arbitration agreement can be compelled to arbitrate. Grounds on which courts have held non-signatories subject to arbitration include incorporation by reference, where an arbitration clause is incorporated by reference into a contract signed by the non-signatory.
An arbitration clause is incorporated by reference in a contract signed by a non-signatory. Interesting, ain't it? Let's continue.
Assumption by conduct. That is, a party may be bound by an arbitration clause if its subsequent conduct indicates that it is assuming the obligation to arbitrate. Alter ego. For example, where the relationship between a corporation and its subsidiary or principal is sufficiently intertwined to justify piercing the corporate veil, so as to hold a non-signatory subject to the arbitration agreement of another corporate entity.
Equitable estoppel, that's what we're looking for.
Equitable estoppel. For example, where a non-signatory who is sought to obtain the benefits of a contract containing an arbitration is stopped from denying the obligation to arbitrate under it.
Interesting.
11. In what circumstances can a party that is not a party to an arbitration agreement compel a party to the arbitration agreement to arbitrate disputes under the arbitration agreement? In 2009, in Arthur Anderson LLP v. Carlisle, 129 Court. 1896, 1900, 2009, the U.S. Supreme Court, in line with decisions of many state courts and lower federal courts, expressly rejected the notion that only a party to a contract can enforce its arbitration clause. As the court observed, because the Federal Arbitration Act aims to place arbitration agreements on equal footing with other contracts, arbitration agreements are likewise subject to traditional principles of state law that allow a contract to be enforced by or against non-parties to the contract through assumption, piercing the corporate veil, alter ego, incorporation by reference, third-party beneficiary theories, waiver and estoppel, at 1902.
Waiver and estoppel. Love that word.
Where U.S. courts permit non-signatories to compel arbitration against parties to a contract, they typically invoke one of the following principles, both grounded in notions of estoppel. Courts have held that where a signatory to a contract relies on a contract containing an arbitration clause to bring suit against a non-party, equitable estoppel permits the non-signatory to compel the signatory to arbitrate its claims. In other words, courts have viewed it as unfair for a party to rely on a contract to assert claims against a non-signatory, while at the same time seeking to disavow an arbitration clause found within the contract to avoid arbitration. Courts have found application of equitable estoppel warranted where a party to a contract containing an arbitration clause asserts claims of interdependent and concerted misconduct between a signatory and a non-signatory. In such instances, courts have found plaintiffs stopped from arguing their claims against signatories and non-signatories are separate for the purpose of avoiding arbitration. Separability 12. Does the applicable law recognize the separability of arbitration agreements? The U.S. Supreme Court has adopted the presumption that arbitration clauses are separable or severable from the underlying commercial contract in which they are contained. Prima Paint Corporation v. Flood and Conklin Manufacturing Company, 388 U.S. 395, 1967.
I am actually...
Therefore, typical defenses to the enforceability of an underlying contract, such as fraud in the inducement, duress, illegality or unconscionability, are not typically viewed as undermining an arbitral tribunal's jurisdiction to adjudicate disputes arising from a contract with an arbitration clause, unless a party can attack the validity of the agreement to arbitrate itself. Buckeye check cashing v. Cardegna, 546 U.S. 440, 449, 2006. Where there is a challenge to the validity of the contract as a whole, it does not specifically implicate the arbitration clause. The matter should generally be referable to arbitration.
That's the case law that was included by Mr. Stark.
Breach of an arbitration agreement.
Uh-oh, I lost it again. Ladies and gentlemen, you can find that at this particular website. And this is, let's show you the website. Practical Law. It's ukpracticallaw.thomsonreuters.com. Okay, and it's Arbitration Procedure and Practices in the United States Overview. That's your complete title for doing the search for finding this page. Okay, but it will go over, give you a better understanding of arbitration, what's allowed, what's not allowed. This is what has been put into place. Why? Without ever reading this, these are the things we have been solidifying. These are the things that Bradley Christopher Starks took care of on his own. I've been going behind him, making sure he covered all the bases, and I'm finding out, as you are, that he covered all the bases. So when we have people who don't understand the process, I say go over this, read over this, let it play over and over and over again. Don't do like I did and have so many systems running and so many windows open that it can't take care of what it needs to take care of. But there you go, ladies and gentlemen. This is to let you know that it is a viable process and that the courts have consistently recognized it. And by the way, here's the thing. To deny us would be to deny every other case out there. Okay? Because they're going to come at us. We know this. Why? Because the individuals, when they went to Congress, they took care of things. That's why bring the state into your agreement. Make it an agreement with the state, but you cannot put clauses in there which imposes an obligation on the state which will violate the law in the first instance. That's illegal. All right, ladies and gentlemen, I gotta go. There is a lot of work that needs to be done, so we will talk to y'all's another time. Yeah, I know a lot of videos lately, but I told you this is all for you all now. Okay? Have a good day.